Let's look at the legal side of health and safety. If we look at legal, we have to go back to the creation of the Health and Safety at Work Act. To look a bit further back in terms of health and safety law, we need to look at the common law duties that were there first. The Health and Safety at Work Act is technically built on a group of common laws which were established first. In the past, before the Health and Safety at Work Act was in place in the UK, there were common laws that basically were formed due to certain activities that happened in the UK whereby individuals were harmed or situations occurred whereby people were at loss, sometimes injury, sometimes property, sometimes fires, whichever the case may be. What therefore happened is the person at loss or the company at loss or the individuals or even the government took a company to court for redress. They sought compensation or they needed to return people to an original state. Now, some of these laws became so important that they became the employer's duties in common laws, and breaching them was called a tort, a civil wrongdoing. Following a major industrial incident, the Aberfan incident in Wales, where a miner's waste slide slid down a hill and buried a village and a lot of the children that were in a school, and that caused a generation to be lost from this village, Lord Rowlands was commissioned by the UK government to create a statute, a law of the land, the Health and Safety at Work Act. In 1974, that law came into practice, and that set the laws for punishment. Before, there was only redress, so you had to compensate and return them to an original state. But the individuals responsible didn't seek any kind of need to protect themselves from things like criminal conviction because there was no laws. 1974 then made the Health and Safety at Work Act, formalize that, and now people can be punished. So that means that Health and Safety at Work Act states the ground rules, i.e. the laws and regulations that are made from the Health and Safety at Work Act, which we must follow. If we don't follow them, later after the Health and Safety at Work Act was created, the Health and Safety Authority was created called the HSE. The HSE is the Health and Safety Executive. These people will now do regular inspections, make sure we comply with the law, following major incidents or accidents from the RIDOR regulation, the Reporting of Incident, Diseases and Dangerous Occurrence regulation. If there is a dangerous occurrence that requires you to report it to the HSE, they have the chance to come and visit you and look if we followed the laws and we were compliant. A lot of people dread the HSE, but if you look at it really, in a year there are only 300 court cases from the HSE. Now, people dread these visits because HSE can issue notices and can take actions against responsible persons, employers, companies, based on these health and safety breaches. To make sure we work within the boundaries of the law, we need to have competent assistance. The Management of Health and Safety at Work Regulations 1999 stipulated that an employer should seek out competent assistance to ensure they knew what to do and work within the boundaries of the UK safety law. Therefore, people like yourself or myself holding managerial positions, directorate positions, or even in general, we needed to learn about health and safety law. It is now common practice in the UK that health and safety laws should be basics of what managers know, what directors know, and that health and safety employees are there. Committees are made, we even have unions, and we have to consider, therefore, in nearly every major company, there should be a health and safety department. These will then check for all the legalities in terms of which laws we need to comply with, and they will make sure that they check them. The way that you check them is obviously checking all the laws, but this is going to be very difficult because they're written very formally. You can look at a proof code of practices and health and safety guidances if you go to the HSE website and in the search bar just put full catalogue. A full list of them will come down, and this helps employers, people, really to understand more about what is required. And they're written in plain and simple English so that we can really easily interpret them. They're not in formal language, so it should make it easy. If we don't follow, we know what happens. We've already mentioned it. Fines, prosecution, and obviously in worst case scenario, imprisonment. So let's do our best to avoid that and consider our legal obligation.